Welcome to the Connect, Practice, Track, and Grow podcast. Habits, routines, motivations, and mindsets from some of the most successful real estate professionals among us. Check out the show notes at connectpracticetrackgrow.com. This show is brought to you by the strategic resource for real estate professionals, creating and coaching business opportunities and strategies that support and add value to the lives of real estate professionals at thestrategicresource.com, and by Roost Real Estate Company. Today's real estate agent doesn't follow old rules. She makes new ones. Learn more at careerwithroost.com.
Hi, Chris McAllister here, and welcome to the Connect, Practice, Track, and Grow podcast. I'm here again with my compadre, Laci LeBlanc, and this is part two of our discussion, understanding the recent civil decision in Missouri against the National Association of Realtors. So, good morning, Laci. How are you?
Good morning. I'm great. I've had a little time to digest the last conversation we had about this. And I've got some questions that I'll hold and see if you answer them, but I'm ready to dig a little deeper.
So part two is dive into the, quote, mega brokerage response to the lawsuit. And I have to tell you, for me, this is where it gets interesting. I know it's a little bit of inside baseball, but I think it's critical to separate, what has happened from what may happen. So before we get started, is there anything that you thought about that wasn't clear last week that we should talk about before we dig into this?
No, I think we're hitting on it. I think it's really just more of a clarification of this part is to me the most interesting part. Is why did some of the folks choose to go to trial and why did some not, right? Why did they settle?
Yeah, that's the thing I thought was really interesting. So that's my question to myself as I was doing the research was, why did Home Services of America and Keller Williams choose to go to trial? And, I said last time, I did a lot of deep dive research and, found a ton of articles from different sources and printed them out and read through them in detail. That's how much fun my life is, Laci. And there's a few possible reasons why they chose to go to trial versus settling. And strategically, these are obviously big companies. And one potential reason why they went to trial was to set a legal precedent, right? They may have seen this case as an opportunity to, set some legal groundwork that can benefit them in the future against, any other antitrust lawsuits that could come down the pike. So taking the case to trial, and it could basically, obviously, it could potentially help them going further, but, in the future, but that's just speculation. The other reason that they may have chosen to go to trial is to shape public opinion, right? They think that, by taking a stand, something they believe in, and I can't disagree with that. I believe in it also, they're doing what's right. They're presenting their case in court.
You've just done something a little similar to that, right? You're taking a stand. I think we talked about it on the last landlord profitability podcast. It was an ordinance in Ohio, and you're taking a kind of stand against that. So I guess if people want to hear more, they can go and take a listen there. But yeah, I think that is important. I think that shaping public opinion and letting people know where you stand. But overall, just, this National Association of Realtors thing, even for people who are not in the industry, a realtor is synonymous with someone you can trust when it comes to buying and selling your house. So
yeah.
to put that under scrutiny, is big for folks. So
and I think it's good that they stood up for themselves. I have to admit that I'm not questioning their decision. I'm just curious as to what went into it. And the other reason is, they could have settled, but maybe they wanted to avoid settling for what they felt was a bad deal. Maybe they felt that they could get, by going to trial, things they were going to get a better deal. But the last thing they want to do is, quote, get a bad deal and that could financially harm them if they had to pay out a lot of money. The other thing is, and again, this goes back to doing the right thing, they felt that by going to trial, that they were better served as a means to protect their brand reputation. And essentially by going to trial, they're defending their realtors, which I also applaud. And that to settle, whether they admitted guilt or not, but just the act of settling could potentially damage their brand reputation. So, going to trial gives the appearance, not the appearance. I think it's true for them that they're fighting for what they believe in. But it's complex. There's a lot of different things, and we have no idea. It's not like, Keller or Home Services are out there. Here's the reasons why we did this. But I think we can only assume that they believed in their cause and it was the right thing for them to do. So if that's why they did what they did, why did RE/MAX and Anywhere Real Estate choose to settle, right? I mean, these are four, well-respected legacy companies. They've been around for a long time, insanely successful. Two of them chose to go to trial and two of them chose to settle. So why? That's the thing that gets me excited, which is a little sad, I guess. But in any case, so
no, I'm jealous of the excitement in your life, Chris, over this. I think everybody should have something in their life that they feel this passionately about. So I think it's fantastic.
So what's the reasons? Well, maybe they wanted to reduce legal costs. And more importantly, maybe they wanted to reduce uncertainty in their business and amongst their realtors. Settling the lawsuits before trial allowed both RE/MAX and Anywhere to avoid costs. Trials can be lengthy, expensive, and unpredictable, just like the outcome to this could have been predicted. The outcome, as we've seen, is never guaranteed. And I just want to also reiterate, I still believe that the National Association of Realtors and Keller and the rest of the plaintiffs, I believe they will prevail on appeal, for all the reasons we talked about last time. So I don't want to imply that, I think that this decision was correct. My personal feeling is that it was not correct, but that doesn't mean it doesn't have ramifications for our industry. The other reason RE/MAX and Anywhere may have settled is to avoid any negative publicity and damage to their reputation. Just like the other folks that went to trial thought that going to trial was going to enhance their reputation, I think RE/MAX and Anywhere felt that avoiding trial was going to avoid damage to their reputation. So, maybe they were playing a little bit of defense there.
Yeah, I think it's interesting that you can kind of swing this either way. And we can look at it as the organizations that went to trial were doing so to protect their realtors and their business and their brand. And the ones who didn't were doing so to protect their realtors and their business and their brand, right? So I think that's an interesting two-sided coin there.
And also for the folks that settle, it allows them to just move forward and maintain control over the outcome, right? So by negotiating a settlement, they avoided the risk of a bad verdict from the jury or judge, because that's always unpredictable. And they were able to protect their interests and minimize any potential harm. It also allows them to focus on, their day-to-day operations. I don't know if any of you out there listening have ever been involved in any sort of lawsuit, but it takes a tremendous amount of bandwidth away from you, right? The actual hours of the day or minutes of the day that, you have to work on something like this may be small, but the amount of space that these things take up in your brain is large. So settling allows them to focus on what matters and what makes money and taking care of their agents.
Yeah. I mean, when you think about it, whatever the decision is on appeal, right, applies to everybody. So if you've got folks appealing it, and so it turns out that we can move forward just as we were, or whatever the case may be, that's really going to apply to everyone, right? So they got to control the outcome at this point, regardless of what happens in the future, because other folks, which I don't guess they had knowledge who was going to go to trial or not, but the same outcome is going to happen whether these folks decided to go or not, because other people are going, right?
Yeah, I just find it very interesting that basically from what we can surmise are the exact same reasons protecting their clients, their agents, their franchisees. They just took two different tacks. And I don't think either one of them was right or wrong. I think they did what was right for they and their businesses. So I dug pretty deep to try to figure out what the terms of the settlement were. And this is what I was able to find out. So this is from various Google searches and different news searches to different places. But RE/MAX and Anywhere agreed to, and anybody can check my facts. Again, I only use what I believe are trusted sources. But RE/MAX and Anywhere agreed to pay $55 million and $83.5 million respectively to the plaintiffs. Obviously, RE/MAX and Anywhere were the defendants. I think I misspoke earlier. This is the thing that's interesting. RE/MAX and Anywhere agreed to stop requiring their agents to be members of NAR, which means they are no longer required to follow NAR's code of ethics or their MLS handbook. And we're going to talk a little bit more of that here in a minute, but I thought that was a very interesting and potentially consequential outcome of settling. RE/MAX and Anywhere also agreed to implement revised policies regarding offers of compensation to buyer's agents. So this goes back to that whole thing about, the cooperation agreement that we talked about last time. RE/MAX and Anywhere also agreed to provide training for their agents on antitrust laws and the implications of the settlement. And both of these companies agreed to cooperate with the Federal Trade Commission in its ongoing investigation into antitrust allegations against the National Association of Realtors. So I found I thought those terms of the settlement were really interesting. And the question that comes back to me is, RE/MAX left NAR, RE/MAX and Anywhere left NAR. And I'm a former RE/MAX franchise, so I have a lot of respect for that company, and I like to feel I know it pretty well. And so what could be those reasons? Well, RE/MAX and Anywhere, I think what it comes down to is, and I'm thinking out loud, Laci, forgive me, but it does come down to antitrust concerns, right? There's a lot of noise out there in the world. There's a lot of noise at the federal level that there are antitrust issues with the way realtors do business. We don't think that's the case, but at any given time, tough environment, economically, et cetera, there are different administrations. There can be concerns about antitrust. So their response to attacking these antitrust perceptions head on was to stop forcing their franchisees and agents to be members of NAR.
I think that's the fact that they agreed to cooperate with FTC, right? With the allegations, right? That was the only part of the terms of the settlement that raised my eyebrow at, because it feels a little snitchy. Does that make sense? Like if we're all one big family of real estate agents here, that feels a little snitchy. But I do think that illustrates this point, that if they're worried about the antitrust moving forward, then and that's standard. I'm sure, I'm not a lawyer, but to agree to cooperate is just kind of part of the deal. But yeah, I didn't think about it as much from that perspective until now, and the antitrust part of it. But you're right, it's always out there, in every vertical, in every industry. That's always kind of hanging over folks' heads. So that makes sense that it would be. And the consequences are huge, right, for that.
The other thing that came up was that RE/MAX and Anywhere did not want to continue to be, quote, constricted by the clear cooperation mandate from NAR, which I find that interesting. So they objected to NAR rules that they believe restricted competition and harmed consumers. So they objected to NAR's rules. Their transparency around commission rates was limited, and that it prohibits agents. Well, and again, this is so inside baseball, but one of the things they were concerned about was most of the MLSs, I think all of them, that you're unable to sort listings by commission amount. Now, you could argue, why would you want to do that? Well, there is an argument that agents are only going to show houses for which there's highest commission. To me, that feels like it sort of goes against, what we all stand for with clear cooperation. But one of the reasons that they chose to settle was they want to be able to do what they want to do and what they feel is right in conjunction with state licensing laws. And they felt that to some degree, current NAR, as good as we might think they are, as I have always thought they were, that RE/MAX and Anywhere may feel that they're too restrictive on their businesses and on their agents than maybe we felt, right? The other thing is,
I guess that makes sense to me. I didn't think about that either.
Strategic flexibility. So by leaving NAR, these companies get to experiment with new business models and pricing strategies that could allow them to better compete with other real estate brokerages and online real estate companies. That, to me, is the most interesting part of this, that they felt constricted by NAR, that they can't come up with new business models and so forth. And when you think about where we are at this point with technology and AI and then Zillow and all this other stuff, we don't know what we don't know. And when you're inside that realtor box, it's hard to see what's going on outside of the box. And I'm really curious as to what these, quote, new potential business models look like that could be so compelling and potential money makers that it would cause them to walk away from the National Association of Realtor framework. The other thing is costs. NAR membership fees can be expensive for large brokerages, and leaving NAR could save a ton of money in dues for, these agencies, franchisees, and so forth, and choice. They may have believed that leaving NAR would ultimately give consumers more choice and improve the quality of the real estate services. I feel like some of these speculations are implying that RE/MAX left for, I think what's interesting is it feels like these companies left not just because it didn't make sense to fight and because they wanted to protect their interests as an organization and their realtors, but I find it just incredibly interesting that they also left in order to pursue a new way forward, right? A potential new way of doing business that, maybe it has to do with the whole decoupling thing that we talked about last time, but maybe there are things out there that people are thinking about that, I in particular have never thought about. And I got to tell you, I'm excited to see what they come up with.
Same,
so regardless,
same.
Regardless of what happens on appeal, the fact that they left NAR was a significant outcome of this lawsuit. So what does that
now
mean?
My brain is reeling with what could they be like cooking up. That's what
exactly. So what are the effect on franchises? So no longer will RE/MAX offices franchisees be required to be members of, and they are welcome to be members of NAR, but they will no longer be required to be. So theoretically, these franchises will have more flexibility to set their own policies and procedures. They're going to save money on dues, but obviously the fact is that the vast majority of MLSs in the country will only allow you to join if you're a realtor. So does that make the point? It turns out that there are MLSs in the country, very few, and maybe this is you don't have to be a realtor to join, because when you think of any antitrust issues, it seems like it's the MLSs that could potentially have some concerns if they're, barring people who aren't realtor affiliates. So and again, I think I'm miswired, but I just think what's going to happen, I'm just excited to see what goes on. But there are reasons why the franchisees would love the flexibility not to have to write checks to the NAR every year.
Yeah, I think to me, that's where we start to, in my mind, and as a consumer, I think, well, if they're not a member of the NAR, right? If they're not a realtor, then what are their standards and where can I read those and find those? And I know not all folks are maybe as ingrained in this as I am. So, but I think it's a major decision, right? It's for some people, the biggest decision they'll make, buying or selling their house. And so that's where I start to think, where are they going to define kind of their code of ethics? And because I'm sure they do it aside from the NAR existing, but it's going to have to be more prominent, I think, right? Is that a concern for you? Or
well, I think the NAR has done a really great job of keeping everybody honest for over 100 years, right? They have also done a great job of influencing state law, and for the better. That's, basically the reason for existence. So, what happens if, going down the road that NAR no longer plays that role? Does that mean somehow these big companies are going to play that role in shaping policy, laws and so forth at the state level and potentially at the federal level? I think that's probably the case, that these companies in and of themselves have to have a seat at the table because they are just as big and powerful, quite frankly, as NAR. But, potentially this could have a huge effect on NAR, which we're going to, talk about that next time we get together. But I think at the end of the day that you have to wonder, as I say this, as I think about this, thinking out loud, if these two companies settled because they want to disengage from any future antitrust lawsuits and so forth coming down the pike. And, as I said last time, this does feel like sort of a populist uprising against the real estate industry and realtors. And it feels bad for us because it's been a very tough year. But, strategically, if you as anywhere in RE/MAX can sort of step away from those, antitrust challenges coming and allow yourself to build some new business models around how the industry is changing, then, more power to them.
Yeah, for sure. again,
it's not like these
my brain is like,
anti-challenges and accusations are going to go away. I don't think they are, even after the appeals process runs out on this. So I did some more research on this whole MLS participation by non-realtors. I asked the question, can licensed real estate brokers who are not members of NAR list properties on the multiple listing service? And it turns out, yes, they can, but not in every single situation. So, practically you can leave NAR, as a company policy. I don't know if in a day-to-day basis, people are going to be able to leave NAR because the benefits of being on the MLS are so great, and very few MLSs are allowing anybody who's not an NAR member to participate. So at this point, I think that's a moot point, but it does potentially open up a whole nother can of worms.
Yeah, so when you talk about the MLS, what are the benefits that would be hard to recreate without it?
Well, the beauty of the MLS is you get increased exposures for your listings, right? So the whole beauty of Clear Cooperation is we have these organizations that we support, pay money into, called the Multiple Listing Services. There's many of them across the country. They're regionally put together. And every person who takes a listing, every realtor or brokerage that takes a listing, it goes into the Multiple Listing Service. And in addition to that, we offer compensation to anybody that brings a buyer, right? That's where the market making happens. That's where the magic happens. One of the things that I am amazed at is that as soon as this ruling came down, and I think we belong to 5 or 6 MLSs, there were 2 MLSs that within a day had sent out notices that, quote, now you are allowed to list a property and offer a $0 co-op. Now, I was always of the impression, and maybe it's because of the MLS that we've always worked the most in, that it was never a defined field that you had to put a certain percentage or a certain dollar figure in. And quite frankly, you've always been able, and like Rist, where we, encompasses most of Springfield and some of Dayton, that, you could make changes to that cooperation structure because, that's a decision that you make with your seller. And it was never necessarily a defined field. And sometimes flat fees would go in there, right? During, after the crash, we had all those bank-owned properties, and the banks wouldn't pay a percentage, but they would pay a flat fee of, say, $1,000, commission, and then half of that would generally be split with whoever brought the buyer, right? So, but it turns out that evidently that wasn't the case for every MLS in the country. And more important, if there was an allowance for making variable fields in the co-op, that 0 wasn't an option. So if 0 is not an option, it sort of does feel like that's an antitrust violation, right? That's definitely an antitrust concern, because if you're saying that all commissions are negotiable and that contract is between the seller and the listing brokerage, that's all fine and good. But if for practical day-to-day operation, if that seller says, well, I don't want you to give any of your money to the other company. I don't even want to offer the other company everything. I'm willing to pay you what I agreed to pay you, but I want you to keep it. I don't know that has ever happened. I don't
right. It's
know.
just so weird. That's I'm just thinking day to day, practically what a conversation would look like.
if you're going to say that commissions are negotiable, right, and that we're not all in cahoots, and you have to put something in for a co-op, a dollar figure at least, well, that does sound like, I don't know if collusion's the right word, but it does sound a little creepy in light of this decision. So I thought it was interesting that suddenly every MLS that we work with made it clear that you can offer $0 compensation. And to me, that is a huge outcome with potential consequences down the road to different business models and Clear Cooperation and everything else, that practically now you could put a $0 in there. And that means that a seller could, a couple of things could happen. They could say, well, if you're going to charge me 6% and 3% is going to go to the seller, well, I don't go to the buyer. I want you to sell my house. That's what I'm paying you for. I don't want to offer any money. So, I'll pay you 3%, take it or leave it. And I don't want you to co-op. Or like we just said, somebody could say, no, I want you to sell my house. I'm willing you to pay for it. I don't care if it's 6%. I don't care if it's 10%, but I'm hiring you to sell this property and I don't want to co-op for whatever reason. And now that's a possibility that in some instances was not a possibility, less than 6 weeks ago.
Right. So let me ask a kind of a devil's advocate question here. So it does seem weird now that we're thinking about it, right? That the seller has a say in, okay, I'm going to pay this much money for you to sell my house. And here's what I want you to do with it, right? That's like, oh, well, here's your paycheck. Now I want you to spend, 50% of it on your bills, and I want you to tithe 10% and save, right? So, but it's built into the original contract. So that,
Yeah,
and that seller, right? So now,
right. But the seller does have to say that the seller has to agree or not agree to offer compensation. They have to be disclosed that we're offering compensation. So you're right. If you're, and this goes back to the reason why it's very likely that the realtors will prevail on appeal is, does this add a violation of the contract that's signed between the seller and the brokerage? But if that contract doesn't allow for, or doesn't obviously allow for the split between the split of that payment, I think that's where the whole legal argument comes in. And it's very complicated. It's very esoteric. It does feel like it gets in the way of that contract between the listing broker and the seller. But then when you think about it, then it does feel like that the whole system, to some degree, and I hate to say this out loud, but I can see how people would think that the system is rigged in favor of the realtors if the seller has no say in that. And that's where the accusation becomes, well, that's how you're fixing prices. That's how it's antitrust. That's how it's always, X% that people always pay. So it's just one more reason why this is such an incredibly complicated thing. And obviously it can go either way because it has gone either way. But I still think that there's a darn good chance just on the merits that the realtors will prevail on appeal. But if they don't, the cat's out of the bag, right? Things have already started. Things are in motion. Things are changing. Some of the companies are, the big companies aren't going to, basically follow NAR's lead anymore. They're going to go out and they're going to follow their own lead. And I think that's what's the most interesting thing to watch as we go forward in the months and years to come.
Yeah, well, I mean, we're operating under the assumption that if, say, now a seller doesn't want their realtor or real estate agent to split their commission, we're assuming, I think, that the buyer's agent will be paid then by the buyer. But where does it say that, right?
Yeah, but that gets into the whole.
As an agent to say, okay, I'll pay, I'll split my commission. They've given me the 6%. I take it all, and then I'll split my commission as a finder's fee or, some other terminology. Like, where's the regulation around that now? Now if that's the case, now it's kind of unregulated, right? But
that's the key is there's still a difference between what NAR says is okay and what state law says is okay. And, I am far more concerned on a daily basis about what the state has to say because they're the ones that can yank my license. NAR basically can't yank my license. They can throw me out of the club. So,
man, there's so much more to unpack about this.
I know. And it just is mental gymnastics. And, it may all be for naught. But like I said, I do think the things have already gone into motion. Things are already happening. And at the end of the day, I think commissions will continue to be compressed. But to your point, Laci, I don't see buyer agents going anywhere, right? You can't, what a buyer agent does or has to do, to get a first-time buyer, for instance, into a home these days, that is where the magic happens. You can't argue with me that the buyer's agents are overpaid. You cannot digitize, educating and coaching a first-time buyer through their home purchase. You can't digitize taking their parents through it, right? I mean, I can't tell you how many times, agents think they've got the perfect house, the perfect deal, everything's great. And then the parents show up for the whole house inspection, right? And then all of a sudden we're renegotiating everything. And I mean, the buyer's agents, I got to tell you, to think that buyer's agents are overpaid or to attack agents over this, that the process that they do, the service they perform is going to have to be done by somebody, and maybe they're going to have a different title than buyer's agent. But the fact that we're attacking buyer's agents are the ones that are being overcompensated in this is I feel like it's just dead wrong. And we're going to get into that later when we talk next time, because next time is my question, the working title for part 3 is, how did we get here? How the hell did this happen? And I want to talk a little bit about that with you next time we get together.
I look forward to it. I think this has answered a lot of questions that I had after last time. I think the order is perfect. I will say that I bought a house from family, and my Nana, as we've talked about before, was my real estate agent, and she took no commission, bless her heart, but she really did earn something because it is, you're exactly right. The buyer's agent, for especially a first-time home buyer like I was, is really doing a lot of the legwork and the emotional support.
And the other thing that Clear Cooperation does, it makes sure that every buyer agent gets representation. And again, agency is a legal term. Compensation isn't the same as agency, but it does mean that every buyer, regardless of especially if they don't have money to pay their own agent, right, as an extra closing costs and so forth, it means that every buyer gets representation. And, you want to believe that every agent, of course, is skilled and abreast of market conditions and so forth. Think about it these days. Interest rates are high. A good agent's going to know how to ask for closing costs and how to use those closing costs, either to get a buy down on the mortgage to lower the initial monthly payment, navigating whole house inspections, helping, the buyers and buyers' parents, quite frankly, understand that, let's look at the things that could adversely affect habitability of the house, and let's set these other ones aside that are, costs of home ownership, right? I mean, there's so many things just in the realm of contingencies that, buyers agents earn their income and in many cases more. So, all right, I'm preaching, but I'm down with buyers agents. I think this whole thing is interesting. I think it's a little bit scary. I still think there's a good chance that the realtors are going to win on appeal, but even if they do win on appeal, changes are coming, and we need to not just anticipate those changes, but the new real estate professional needs to capitalize on those changes. So that's where we're at today.
And next time we'll talk about how we got here.
Okay.
It's been a pleasure,
great.
Chris.
Thank you so much. And there we have it. Thanks for listening in. If you want to continue the conversation, go to www.connectpracticetrackgrow.com. That's connectpracticetrackgrow.com, where we have additional information about the podcast, archived episodes, and an option you can select to be a guest on the show. We'd love to hear from you. So that's it. We'll be back next time with another episode of the Connect, Practice, Track, and Grow podcast.